Hello, my name is Kellie Joyce. I am a partner at Secrest Wardle in our Troy office, and today I am going to be talking to you about the use of statutory immunity in defending ski area claims. This webinar will discuss the Ski Area Safety Act, which you'll hear me call SASA. That's an acronym for the Ski Area Safety Act, SASA. This presentation will discuss several areas of the Ski Area Safety Act. First, we'll talk about the definitions and scope of the Act. We will talk about the immunity provision in the Act and its application to hazards identified therein. A big part of this presentation will talk about the immunity provision and the applicability of the immunity to hazards that are not identified in the statute. We will talk about the application of immunity to chairlift injuries, the problem that the Act has with tubing, as the Ski Area Safety Act does not apply to tubing injuries, and we will also discuss the use of waivers. I'd like to talk to you first. We're going to start out by talking about definitions and the scope of the Act. The Ski Area Safety Act is generally interpreted broadly. So when there are cases that have been interpreted by the court, generally, and I'm using the word generally, the court has interpreted the Act very broadly and applied that to the facts of the case in order to assist the defendant, who normally is the ski area, in winning the case. So the definitions, the first definition that I think is important is the definition of operator. An operator is a person who owns or controls or who has operational responsibility for a ski area or ski lift. An operator includes the state or a political subdivision of the state. Ski area means an area used for skiing and served by one or more ski lift. It also includes areas for snowboarding. Snowboarding is not specifically mentioned in SASA, but it is included in the definition of ski area. Last, I'd like to provide you with the definition of skier. A skier is a person who wears skis or a device that attaches to at least 1 foot or the lower torso for the purpose of sliding down the slope. This includes skis, snowboards, or anything that straps onto your feet so you can slide down a slope. Now, the definition of a skier does not cover someone who is not wearing something strapped to their feet unless they are a person who is in the ski area for purposes of skiing. So, for instance, if someone is at the warming house and they just took off their skis but they're still in the skiing area and they plan on going back to ski after, and they're walking towards their skis to put them on, that person would be considered a skier under the definition of the Ski Area Safety Act. Some important notes from the definition section is that a ski area must contain a ski lift in order to qualify as a ski area under the SASA. Also, the definition of skier includes snowboarders, which I mentioned in the previous slide. Although the SASA does not specifically talk about snowboarding, it is part of the Act, and a snowboarding area would be considered a ski area, and a snowboarder would be considered a skier under the Act. In addition, anyone riding on a lift or a tow rope would be considered a participant under the Act. So this means anyone who is getting on or off of a chairlift, anyone who is riding on a chairlift, they would all be considered a participant, and they would be subject to the provisions of the Ski Area Safety Act, and they would also be subject to the immunity provision of the Ski Area Safety Act. So that's important, that anyone who is on a lift or a tow rope. Ski areas must comply with minimum safety requirements in order to earn the protection of the Act. Generally, these are signage and licensure requirements. In order to earn the protection of the Act, later on in this presentation, I'll go through a specific checklist that a ski area must follow in order to be protected under the statutory immunity provision of the Ski Area Safety Act. Now, enumerated in the Ski Area Safety Act are skiers' responsibilities. These are enumerated in MCL section 408.342 subsection 1. While in a ski area, each skier shall do all of the following. First, they have to maintain reasonable control of his or her speed and course at all times. Second, they have to stay clear of snow grooming vehicles and equipment in the ski area. Next, they need to heed all posted signs and warnings. And finally, they can only ski in areas which are marked as open for skiing on the trail sign described in section 6A subparagraph E. If they fail to follow these rules, then they would be subject to immunity under the Ski Area Safety Act. So there are obviously a number of violations that a skier could have, and that would hurt their claim. From a defendant's point of view, obviously we would then argue that the skier was comparatively negligent, and that would help in a defense point of view if there were a litigated issue. Now I'd like to talk about application of the Ski Area Safety Act immunity provision for hazards that are expressly identified in the statute. In writing the Ski Area Safety Act, the legislature obviously could not think of every single situation that could arise. So basically, each person who participates in the sport of skiing accepts the dangers of that sport, and those dangers would include, but they're not limited to, injuries that can result from variations in terrain, subsurface or surface snow or ice conditions, bare spots, rocks, trees, or other forms of natural growth or debris, collisions with ski lift towers and their components, with other skiers, or with properly marked or plainly visible snowmaking or snow grooming equipment. If there is something that is not specifically set forth by the legislature in the Ski Area Safety Act, that's usually when the court would get involved, and case law has interpreted some of these little areas. So what happens when something is identified in the statute that is not being used for the purpose of its intended and causes injury? Well, the Act essentially codifies the assumption of risk defense, which means you accept a danger as is if you're a skier. And the case that's on point is McGoldrick versus Holiday Amusements, Inc. That's a 2000 case. And in that case, a hazard was identified in the Act, but it was not used for the purpose intended, and it caused injury. Specifically, the plaintiff in that case struck a pole that was used for a chairlift. So the pole was identified in the Act, but it was not being used for the purpose under the Act. The court got involved, and they found that the hazard was identified in the Act, but it was not being used for a ski lift. But since it was identified in the Act, the court granted the ski area immunity under the SASA. So the defendant's motion for summary disposition was granted, and the plaintiff recovered no money in that lawsuit. The court in McGoldrick essentially said that the clear language of SASA establishes that the plaintiff's injury comes within the immunity provisions. The McGoldrick court interpreted the SASA broadly and basically said that there was immunity that would be granted to the ski area because SASA explicitly states that the definition of ski lift includes a tow rope, and plaintiff in that case did not dispute that the metal pole was part of the structure associated with the tow rope, and therefore it was included in the definition of ski lift under SASA. So we talked about when something was identified in the statute but was not being used for the purpose that it was intended and it causes injury. Now I'd like to talk about the applicability of immunity to hazards that are not identified in the statute. And this is where we get into the Anderson test, which was created in a case called Anderson versus Pine Knob Ski Resort. It's a 2003 case. In that case, essentially, the court found that a hazard does not need to be specifically identified in the statute in order to be subject to the statutory immunity provision of SASA. The court created two elements that have to be met in order to obtain immunity under SASA. The first is whether the hazard is inherent in the sport of skiing, and the second element is whether the hazard is obvious and necessary to the sport. If the answer to both of those questions is yes, then the immunity provision in SASA would apply to provide immunity to the ski area. The Ski Area Safety Act also provides immunity to chairlift injuries, so not just skiing injuries, but also chairlift injuries. Again, the SASA grants broad immunity to ski area injuries involving chairlifts. Chairlifts, it's important to remember that chairlifts can also include tow ropes. And the immunity provision would be in effect even if there are claims that are for negligence on the part of the chairlift operator. And the case that I'd like to point out to you is Kent versus Alpine Valley Ski Area. It's a 2000 case. And in that case, the court stated that other than generalized opinions that the stop button should be utilized whenever there are children involved, and that any lift carrying children should be equipped with a slow button as well as a stop button. In this case, the plaintiff's expert conceded that the lack of a slow button did not violate B77. The plaintiff's expert pointed to no factual evidence to establish statutory violations by defendants that could affect the otherwise unrestricted immunity for operators when a skier collides with the chairlift. So in that case, there was a broad interpretation of SASA, and the court applied the SASA to claims of negligence against a chairlift operator, because we see a lot of injuries coming from people getting on and off a chairlift. That's where a lot of injuries occur, because it is kind of difficult to get on and off of a chairlift. Sometimes there'll be an injury because the person in front of you is having difficulty getting off the chairlift, and the chairlift operator doesn't slow down the chairlift in time, and you ended up toppling over on top of them. So broad interpretation applies to chairlift injuries. A lot of times I'm not sure if how many of you are familiar with premises liability claims, but in premises liability, a lot of times the plaintiff tries to get around open and obvious defense, which is by pleading active negligence. An open and obvious defense is basically means that if there's a hazard that is readily observable to a user upon casual inspection, that the owner of the land has no duty to warn of any hazard. Similarly, in case ski area injuries, plaintiffs will try to plead a claim of active negligence in order to try to get around statutory immunity. And the court, again, has found that even with cases of active negligence, SASA still applies, and there is statutory immunity that would be granted to ski areas as long as the enumerated, everything has been followed under the Act. Now, the Ski Area Safety Act does not apply, unfortunately, to tubes. Courts have concluded that tubing is not covered under SASA. And a tubing is, I'm not sure if any of you are familiar, but tubing is essentially where you would take a tow rope up and you ride down a tube. It looks like skiing, it smells like skiing, but it is not skiing, and the court has interpreted it to not be included under the Ski Area Safety Act. So although the Ski Area Safety Act grants broad immunity to ski areas involving chairlifts, it currently provides no immunity for snow tubing. The best defense to address injuries from tubing would be to have, in my opinion, I think you should have tubing lanes that are groomed specifically for tubers. These areas could be roped off or enumerated by signs. Additionally, it may be best to have waivers in the tubing area. The signs that you may include and possibly would be a stop sign, or maybe to have a haystack or an inflatable barrier, a sign to say slow down. Unfortunately, because the Ski Area Safety Act does not apply to tubes, the best defense that you have is signage and waivers. Usually, waivers are upheld to address liability for adults, not children, and we'll discuss that later. But for adults, waivers are upheld. Also with tubing, if you put a sign on the front and the back end of the tubing area, you can put something that says, do not tube faster than you can control, do not touch other people tubing. In those cases, if you do have all of these in place, if a case were to go to a jury, we could make the argument that the ski area was being reasonable. There were signs available. There was a specific roped off area for the tuber, and there's been a waiver on the back of the ticket, and therefore there should be no liability found for the ski area. Those are the arguments that we make. Now, to address waivers for liability, waivers have been valid and they have been upheld by the court as to adults. And the case that is specific on this area is an older case. It's Paterick versus 6600 Limited. It's a 1990 case. And in that case, there was a man who was playing softball. Prior to playing softball, he signed a waiver, but he was injured while he was playing softball. And in that case, the court dismissed his claim because he had signed a waiver, which the court found was a legal detriment, and it induced plaintiff to promise to release defendant from liability, and plaintiff's promise to release defendant from liability induced the defendant to suffer the detriment. So because of those three reasons, the court found no merit in the plaintiff's argument, that there was no lack of consideration, and defendant's agreement to allow Mr. Paterick to play softball was adequate consideration, and therefore the waiver was upheld as a valid legal document. Unfortunately, waivers that are signed by parents as to injuries sustained by minors are currently invalid, and the current case that we have to address that is Woodman versus Kara. It's a 2008 case. In that case, a child went to a bouncy house, inflatable, one of those inflatable blow-up places, and prior to using the bouncy house, the parent was required to sign a waiver. And in that case, the court found that, obviously the children was injured, the court found that a waiver signed by parents would not be upheld for the child because the court would not allow the parent to sign away the rights of the child. So unfortunately, a waiver cannot be used for injuries to children, but they can be used for injuries to adults in the ski area. I'd like to talk a little bit about more about the SASA. The Ski Area Safety Act, although it was created several decades ago, it still is alive and well, and there have not been a lot of cases recently interpreting it, but a recent case is Marshall versus Boyne. It's an unpublished case, and it involved a snowboarder in a terrain park. In that case, there was a variety of places where the snowboarder could do his tricks, and he had gone to the terrain park to do tricks, and he went to a half pipe, and he revisited the half pipe later in the day, And at the time that he revisited the half pipe, he was injured. And the claim that he made was that the half pipe was not visible and therefore SASA should not apply. The court disagreed with the plaintiff in that case and upheld the statutory immunity provision under SASA and found that the ski area or the terrain park had no liability. The snowboarder should have seen the half pipe, and therefore the liability of the terrain park was none, and the plaintiff recovered nothing. And in that case, the court talked a lot about what I had previously talked about, is how that the skier, or the snowboarder in that case, assumes the risk for those dangers that are inherent in the sport of skiing, snowboarding, unless those dangers are not unnecessary. Unless those dangers are unnecessary or not obvious. Specifically, the half pipe area where that snowboarder was injured was marked with signage, and the plaintiff had seen it earlier. So he had already assumed the risk or accepted the risk that was inherent in the terrain. The plaintiff tried to get around the statutory immunity provision of SASA, but the court upheld the defendant's motion for summary disposition. And it's our recommendation in cases where there is a plaintiff trying to get around the statutory immunity provision of SASA, what we've done in the defense side of the case is to send directed discovery to the plaintiff and also file motions for summary disposition, because a lot of times the court will uphold the statutory immunity provision of SASA and find in favor of the defendant. So a motion for summary disposition is the best way to have the case dismissed. I don't foresee the court getting rid of the statutory immunity provision of SASA anytime soon, especially given the Anderson consideration, where as a matter of law there are, even if it's specifically not enumerated in the statute, SASA would still apply. So you have things that are specifically enumerated in the statute, and then if they're not enumerated in the statute, and regardless of whether they're in the statute or not, courts have upheld the statutory immunity provision. So I don't think that SASA is going anywhere anytime soon. So some takeaways from the webinar today is that, in my opinion, I think the statutory immunity provision under SASA is a great way to defend a ski area claim where you have an injured plaintiff, as long as you follow the requirements under the Act, for instance, signage, licensure requirements, and as long as you get a waiver for tubing, because tubing, again, is not enumerated under the Act, and it does not get the same statutory immunity that snowboarding and skiing does. But with injuries from snowboarding, injuries from skiing, even injuries from a chairlift, the statutory immunity provision has been upheld. And then again, you got to go through the Anderson test if something is not specifically enumerated in the Act. Under Anderson, remember, you have to have the hazard that is inherent in the sport of skiing, and the hazard has to be the hazard has to be obvious and necessary to the sport. If the answer to both of those questions is yes, then the immunity provision in SASA applies. That's all that I have for my the webinar today. If you have any questions or comments, you can feel free to contact me. You can reach me by telephone or by email, and that is the end of the presentation. Thank you.